Welcome to Inside the Director Circle and this episode on how to effectively resolve disputes. I'm Jason Langford-Brown, your host, founder of the Director Circle and practicing business advisor and coaching psychologist. Managing and resolving disputes is always a difficult one for leaders. Disputes can often lead to legal proceedings, so in the next episode we will explore how to navigate that minefield. But today we want to explore how we can do this before we even get to that stage, hopefully. And to help us with this, we're as always delighted to welcome one of our knowledge partners from the Director Circle to add expertise to the subject. Today we are joined by Alex Bishop, Managing Partner and National Head of Dispute Resolution at Shoosmiths, one of the UK's leading, award-winning, I believe, and in my experience, one of the most progressive law firms. And to add a practical element, one of our business leaders has joined us all the way from Atlanta, Georgia, Angie Fife, CEO of PDSI, a market-leading property development services firm operating across the US, South America, Caribbean and beyond. And just very quickly, before we get into the discussion, remember this is just a snapshot of what happens within our business leader community. So if you want to get more involved or get some deeper insights, visit directors-circle.com and click Join the Community button. So Alex, can we start with you? I'd love just to start with the notion of what you would class as a dispute. I think in the world of business leaders, the language is often conflicted, and we don't actually talk about disputes very often. We talk about conflict. I mean, are the two things different in your experience or in your professional opinion?
Yeah, no, really good question, Jason. I think you're absolutely right. From a sort of leader's perspective, we think of conflict in terms of that interpersonal conflict, employer-employee conflict, or teams falling out with each other. And so we are absolutely talking about resolving those interpersonal battles. My level of expertise concerns the business-to-business disputes, and that's the terminology that we tend to use certainly here in England in relation to commercial disputes. We're talking there about contractual claims that where two parties disagree over how a contract might be interpreted, or a corporate dispute, shareholder director bust-ups. It could be dealing with issues of fraud or a whole host of different things. And the terminology that we tend to use here when it comes to the court process or resolving those types of issues is disputes and dispute resolution.
So it's interesting. Just reflects on what you've just said there. It's probably when the interpersonal conflict escalates to where it might be legal. It's probably where my HR lawyers get involved. Would that be fair? Yeah.
Correct. Yeah. So absolutely. So when you're talking about employee issues and employee-employer disputes, it is absolutely the domain of employment lawyers, of HR advisors. There is an employment tribunal process here in the UK that would deal with those sorts of disputes. Occasionally, there might be a contractual element to it, which flips it into the court process, but it's the employment tribunal, which is distinct from our court system in that sense.
Yeah, absolutely. So, Angie, I know you're not a lawyer; you're running a business out there in the US, but does it play out that way in the US, or is it slightly different?
It's similar. Everything that Alex described is everything that we try to avoid. And so when we are talking about dispute and conflict resolution, from my perspective, a lot of that is interpersonal, is within our teams, or it is an outcome of misunderstandings within our teams and our clients. And so, getting to contractual disputes is what we pay people like Alex to avoid. And
sure.
Yeah, I mean, it's just so, she's looking at things from a legal perspective. I look at things really from the team and the leadership perspective.
Yeah, but it's the impact those teams can have with your contractual arrangements with your clients, particularly.
Exactly. And so it's our job, to make sure that people do understand what's going on contractually and that there's clarity so that we can avoid the disputes, or we can clarify them, identify them, and clarify them as quickly as possible, which is really the key, in my opinion, to avoiding the disputes in the first place.
Yeah, and I think you led me on to what was going to be my question. Do you have a kind of process you go through to avoid it happening in the first place in terms of from a dispute perspective rather than a conflict perspective?
So can you talk a little bit more about what you're asking there?
Yeah, well, as you said, you've got, and I know for you particularly, you've got big contracts with some big clients. So is it a very conscious thing to avoid disputes? And do you have something you do as a business to avoid disputes even surfacing at all further down the line?
So, one of the most important things is that each of the stakeholders agrees to what our scope is, our scope of work, and that's written into our agreements. And it might be written in broad terms, and then it's our job to define it more clearly. And then it's the job of our team leads to make sure that every person on the team understands what that scope is. Once we start working out of scope, that's where we have some misunderstandings. And then, you have clients who expect a little bit more, or the team who is either over providing or under providing their services. And that's working in that gray area. While, sometimes it can be fun and exciting, is the most dangerous place for us. Jason knows that because I think you've helped us through a couple of those situations.
Yeah, absolutely. But you're right. It's about that upfront piece of work, making that as resilient as possible, and then, as you said, making sure that everyone involved is aware and follows that. And how does that sit with you, Alex, from a professional perspective? Does that sound like the right way to approach it, or how would you see best practice in avoiding conflict or disputes in the first place?
I mean, we will regularly provide full-on seminars and sessions for our clients to help them in exactly that process, because I absolutely inhabit the grey area that Angie's talking about. And without those grey areas constantly appearing, I wouldn't have a job. So, I'm. But having said that, I see our role is very much trying to help our clients to either resolve their disputes or absolutely stop them before they start. And Angie's absolutely right. For me, particularly when it comes to business issues, the contract usually governs those relationships, and getting the contract right from the get-go can avoid so many challenges later down the line. There's a huge piece in terms of that scoping and specification and clarifying the language that is used. And, again, one of my early lessons from a judge was, you've got to explain this to me in terms that a 5-year-old child can understand. And there's a chance then that I might understand it. And I try and apply that methodology. I try and instill that in my, the junior lawyers coming up, try and draft that contract in a way that anyone who knows nothing about this business, knows nothing about these two parties, would be able to pick it up and understand objectively what each party's obligations were. So that's a massive part of the exercise. And then the other piece, when we kind of coming looking at the contract just in and of itself, the bits of the contract that most people find really boring and just skate over are actually the bits that actually, as a litigator, we spend most of our time looking at. And so there I'm talking about things like choice of law and jurisdiction. You might not have applied your mind to it, but, is it a state in the US, or is it England, or is it actually somewhere in Europe? The UK, by the way, everybody, is not a law. There are 3 different jurisdictions. Things like that can really create issues for parties, because what one jurisdiction might do with a contractual breach of a certain nature might be very different to another jurisdiction. Similarly, having dispute escalation provisions in a contract can be really helpful, because you can head things off at the pass sometimes when those conversations start. And then, other things like, is it the court process, or is it arbitration, or some other form of dispute resolution that the parties adopt? All of those sorts of considerations come into play. So, as I say, those boilerplate pieces at the end of the contract are incredibly important. And again, I would urge business leaders, particularly if it's a contract of import, whether that's in terms of value or profile or reputational significance, it may seem really dull, but those aspects, look at the contract with the assumption that things have gone wrong, and then what happens, and make sure that you can navigate your way through in the event that something has gone wrong. So and then the other key thing about the contract that it never ceases to amaze me how often this happens. Things like exit provisions or schedules that you kind of agree to deal with later because you're just so focused on getting the contract signed, and then they never get taken out of the drawer and looked at, and that detail is never there. well, you're just playing into my hands then. You're creating that grey area that Angie talked about, that uncertainty that means that, that lawyers can have a field day, unfortunately.
There's some fascinating points there, Alex, and I'm just wondering which order to pick them up in. But I think the first thing you said about the simplicity really resonated with me. So even in my own corporate career, I think we're always guilty that when you get to a legal document contract, it was always really confusing and didn't really understand it, and you almost just accepted that was just the way lawyers worked, and they like to use big words. But it's interesting you say it should be the opposite. So that maybe that's a bit of a minefield for business leaders to think about, that if it isn't simple, you don't understand it, actually question and challenge that. So maybe we'll come back on that. But that the details in the contract is fascinating as well, and I kind of wanted to link that with the piece you were talking about at the end there, in terms of you almost, I suppose, you need to assume it. The point of the contract is to assume it's going to go wrong, because you're only going to need it if it goes wrong, aren't you, really? So, I'm just wondering from your perspective, Angie, because I know you are working across different territories. Have you kind of learnt the hard way on some of those details before you become as good at it as you are now, I'm assuming?
So I'm happy to say that fortunately we have not had to learn the hard way in terms of a project that's gone wrong. We've learned the hard way in terms of talking to our client too late. To our attorney too late, and him looking at us and saying, why in the world did you just agree to that? Then explaining the ramifications. And then once we're aware, we're like, oh, that was not a good thing to do. So now, we do work in so many different jurisdictions, and finding legal counsel who has expertise in each of those areas has been so important to us, because what we assume for Jamaica is completely different in Mexico. It's completely different in different states in the United States. And our attorney has become one of our best friends. Being able to call him at any time and get really some good sound advice. And sometimes the advice is, this is just going to be a business decision you have to make. And so you can't over-legislate everything. Otherwise, you're never going to have a contract. You're never going to have clients. But you do have to know at least what the risks are when you walk into the room, so that you're not caught off guard. And that's one of the biggest things for us, is the not being too specific in some of our areas in the means and methods by, how we're going to deliver projects.
Yeah, but as you said, you're eyes wide open on those areas, but you've got your jurisdiction right. You've covered the details. But interesting, you're saying that it's that upfront bit that's tripped you up. When you were talking before that about getting the contract right up front, and you talked about scope, Alex, as well. I kind of went into my project management mindset where lots of business leaders, I'm sure listening, will be aware of that kind of feeling, that we agree to do something for somebody and we get huge amounts of scope creep, which is definitely something that Angie will be aware of. And I know when we teach people about that, when we say get the scope and the brief and the estimate up front absolutely right, if that's clear and precise, then it's easy to control scope creep, because everyone knew what you said you would or wouldn't do. And it sounds like from a dispute, it's almost exactly the same thing. Get that scope contract absolutely right from the start, and then you can reference back to that if it starts to go in a different direction, and probably arrest it before it gets too serious.
You're absolutely right. You're absolutely right. But it leads on to another really important piece, and a common cause of many disputes that we find ourselves is actually client may have got fantastic attorneys, lawyers on board, may have done a brilliant job getting the contract right, and may have nailed it. There is then scope creep, but what they've done is that contract goes in the drawer. No one takes it, and no one manages to the contract. So having a project manager who understands that contract inside out and back to front, and it never gets put in a drawer, if it's a significant contract, so that they are constantly referencing back and spotting straight away when something is or isn't in the contract, or where something is unclear. So it doesn't fester and become a massive problem in 6 months' time. You're having the conversation with your client, as Angie was alluding to, as soon as it arises, not when it's hundreds of thousands of dollars or millions of dollars or pounds, because of one party's been carrying on a false assumption.
Yeah. So what you would do then is you would then agree not to do that because it wasn't in the contract, or you just make an amendment.
Correct.
But it's done, again, it's done together, you're aligned, and so you don't move towards a dispute. Yeah.
Exactly. And that's the ideal world situation. In my world, it doesn't always happen that way.
Can you talk about what really happens and why that is, and if that's right?
Sure. So in my world, we are often engaged on a project before a scope, schedule, or a budget are defined. It's our job to put that together. And so it could take us 6 or 7 months of working through a project before we've all agreed on what that scope is. And during that 6 or 7 months, the scope could change dramatically. It could change from what the initial idea is. And so the key, while we say we don't want to work out a scope or everyone needs to know exactly what all the terms of the contract are, if we don't even have the scope defined, then there's a lot of area for us to get into trouble. And that's where I really have to depend on our team leads to make sure that they are documenting the conversations, that they're constantly revising what the draft scope is before everyone agrees to it, so that we can go back and say, no, we took that out and we're not going to be working on it. Because there is an assumption sometimes, that, we've talked about this one portion of a project and it sounds fantastic, but the cost is too high. And then 3 weeks later, somebody expects it because they've heard that conversation, and you have to be able to remind them that scope was taken out. Here's the reason why. Here's who did it. And I know those aren't the fun things to do, but sometimes those are the most important details, to be able to memorialize those things and remind our client how we got to these certain decisions. So, we've had clients who have forgotten what our agreed upon schedule completion date is. And while we might have conversations sometimes about, we think we might be able to get this done earlier, our agreed upon schedule completion date is completely different. And so when there's some conflict about, possible delays in our world, we're looking back at our schedule, we're looking back at our contract and saying, well, we're not really late. What we're doing is, we're suffering the consequences right now of maybe a lack of alignment in logistics, things like that, but we're still on schedule. And those are the difficult conversations to have, because what you don't want to do is say, we've just done a little bait and switch here. We told you we could deliver an X and now it's Y. Here's how we got here. And then they feel like we've been, dishonest with them. So I don't know. That's a little bit of a tricky situation for us.
I wholeheartedly agree with you that it is about keeping those minutes and making sure that you are keeping that record, evidencing what is discussed. And if you had agreed an earlier completion date, let's say, well, that's a formal variation. That again, that's another thing that often trips people up, because they think we've both agreed it, but the contract might well provide for a formal variation process. And if it doesn't comply with all of those, various different requirements to make it a formal variation, there is then an argument, a conflict, a dispute over whether or not it's a valid variation of the contract and whether it has or hasn't been agreed. So you're absolutely right. Having those minutes contextualizes that, and you are able then to point back, well, no, it isn't a variation. We haven't agreed to that earlier date. We can aim for it, but it's in this context, and that date has never moved. Yeah. So, those minutes of meetings, the emails that are sent recording those sorts of conversations, that's absolutely the key evidence that we need when these issues bubble up.
But there's an art to doing that too.
There is.
There's an art, because what you don't want to do is ruin any future sales opportunities with that client.
I think that's probably a conversation we could probably roll, but probably worth flagging. I think you're absolutely right. I think the ability to be able to manage the client relationship in that process is really, really key, isn't it? And I know we've had conversations within your business how that's not always gone well. I think the two things I'd probably pick out of having a chance to see some of your team, Angie, is that is definitely a challenge. Some people do it really well and others struggle with it. But if you get it wrong, it can be messy. But I think also, I know sometimes you hear people almost, because you can't have that perfect finished contracts and scope at the beginning, almost say, well, we can't do it because we can't have it perfect and finished. But I think you've demonstrated there, and I think Alex has backed you up, that you can still work on framing and building that together with the client and managing that process until you get to that final document scope, whatever it looks like. So hopefully that's good practical advice for people listening on the podcast. Okay, I'm conscious of time, but I think there's two things I wanted to do. One was I I wanted just to segue slightly into that more interpersonal, what we would call conflict as opposed to dispute, because I know you're both business leaders, and maybe ask you just to finish the podcast from a conflict perspective, when it's about people and not about businesses and contracts, what's your top tip for handling conflict? And Alex, maybe could I then ask you on top of that, maybe to give your 3 top tips for avoiding disputes in your language, and maybe Angie, you give the same, but from a more practical perspective, if that's okay?
Yeah, okay. Well, so in terms of that sort of conflict resolution, it's your grandma's advice. You've got 2 ears and 1 mouth. Listen twice as much as you talk when you're in that sort of situation. And this isn't from a sort of employment perspective. It's just the sort of broad psychology of just trying to understand what is going on and understanding that everybody's lens is slightly different, and trying to be objective, trying to take any emotion out of a situation. It's that piece that I think I would carry forward to this sort of the more kind of business to business disputes as well. Very often, Angie alluded to this earlier, the lawyers, the attorneys might not be brought in right at the start. They might be brought in later. And they are faced with a very emotional client because things have got heated, they've got personal. And the job of the lawyer is really to try and cut through all of that and work out what the facts are and what the legal position is. And that kind of common sense element. So, I'm genuinely not saying this for the benefit of my profession, but actually involving your lawyer earlier in that process can actually pay dividends because it doesn't ever get as heated. They don't. The other side don't need to know necessarily that the lawyers are on record. They're just giving you that steer that Angie alluded to. This is not a battle you want to have, or giving you the ammunition that you need to go into that business conversation and try and resolve it, face to face. Early engagement with the lawyers. Don't be an ostrich. Take it seriously, but listen and understand, and also try and think about the dispute from the other party's perspective. What are they trying to do? Why are they feeling the way that they are feeling? What might be a route through that they want, and that you might be prepared to agree to. And just flipping it on its head rather than how you've been wronged. If you see what I mean, can always be incredibly useful.
Yeah, absolutely. Thanks, Alex. Angie, for you on the interpersonal conflict side, and then maybe top tips for the dispute resolution.
Well, I wish I could say we had no experience in that, but we do. And a lot of that really is, it just, people are people, their emotions. One thing that can trigger one person, another person doesn't even notice. And I think the key for me is stepping back and trying to understand why we have a lack of alignment in our expectations. What actually got us to this place? Is it something that wasn't clear about our roles and responsibilities? Is it something that wasn't clear about our scope? Is it something that wasn't clear about how we abide with our core values? And so at the end of the day, it's usually something very simple. But we get all of the emotions being thrown in left and right, and all the personal details. And once you have the emotions, anger, whatever else thrown into there, then it really muddies the water. And so having to step back and lean into being brave and using some courage to have a very clear conversation sometimes about what is actually going on can surface a lot of opportunities for a team to improve or a team to change.
Absolutely. And once I think if you say take the emotion out, those brave conversations are much, much easier, aren't they?
They are.
Anything on the dispute resolution side?
On the dispute resolution side, involving attorneys early in the game has always been a key for us. And, that's a standard practice in our business. So that's not something, if our attorneys are reviewing agreements, things like that, that's fine. Before we even get to that dispute resolution piece, again, it's the same thing with our clients and other business leaders. It's what is driving the actual misunderstanding. And so a lot of this can be resolved before people's expectations are even missed completely. And a lot of that has to do with constant communication, checking in. How's everything going? What needs to change? What are we doing well? What do you see that you would like to see differently? So being very proactive is a big thing. And then sometimes you just have clients that you can't work with, and the goal is to work through the current contract. And then we all agree that maybe they're not the right fit for us. And then we decide that that's not someone that we're going to do business with again.
Time to move on. Absolutely. Yeah, absolutely. Thanks, Angie. Thank you both very much. I think some great insights. And as ever, we could talk about this for a lot longer, I'm sure. I actually, it was really interesting when we brought conflict and dispute back together again. I think what I heard there was almost like seek first to understand on both sides of the coin there, really. And I think just a huge need for some empathy. So we can get, as you said, past the emotion, Angie, and then have some good, meaningful conversations out of that. That was interesting. I think for me, I think things that really resonate for me were, actually expect simple. I think that's maybe something that lots of business leaders, particularly inexperienced ones, don't think about. I think they almost expect complicated from lawyers. So that's I think that's a really interesting. But the devil's in the detail. So I think that probably simple, but don't ignore the detail. And obviously we talked a lot about, getting it right up front. So thank you both for all your insights on that. We're going to wrap it up for today. In the next episode, we're going to be joined by Angie and Alex again, and we're going to talk about how we actually avoid the legal minefield if it does come to that. But in the meantime, if you want more info on this subject, reach out to Alex at Shoosmiths and her team. I'm sure she'll be delighted to talk more about all things dispute resolution, or contact us at directors-circle.com. Thank you for listening to Inside the Directors Circle.